Well, the Obama administration suffering a legal setback yesterday as the president's signature piece of legislation, the Health Care Reform Act, was ruled void. This is a Florida federal judge concluded that the individual mandate piece of that law is unconstitutional and thus the entire law must fail. Now the White House is striking back, calling this judge a judicial activist, saying this is a case of judicial overreaching that is, quote, well outside the mainstream. Richard Socarides is the former special assistant to President Bill Clinton and a Democratic strategist. Richard, thanks so much for being here. So I was surprised to see this come from the White House blog. I mean, I would expect sort of outside administration people to make those claims, I guess. But this is on the White House blog. It's posted by Stephanie Cutter, who's an assistant to the president and deputy senior advisor. And as far as I can tell, although she graduated from Georgetown Law, has never practiced law a day in her life. And so she's got to go after this judge. She disagrees with his ruling, but why go after the judge and insult him personally?
Well, I don't think really to call someone a judicial activist is to insult them, first of all. But I think that clearly this is a very important law for the administration. These lawsuits are very important. And this judge's ruling is one of a kind. I mean, there was one other judge that had issue with the actual mandate, but this is the first time a judge has thrown out the entire law, and there have been at least 12 other instances where courts have let the law stand. So I think it's actually pretty fair to say that this is an outlier and that this case is outside the mainstream.
But let me stop you there, because that's not right. She says that as well on the White House blog, that there have been 12 instances in which the law has been upheld. That's not true. There have been two courts. No, let me just set the record straight. There have been two courts that upheld the constitutionality, and now there are two courts that have said it's unconstitutional.
But only one
the other courts that she's referring to dismissed challenges that were filed on technical grounds, like the person bringing the lawsuit didn't have standing, but made no substantive ruling on the constitutionality of the law. So let's just get the facts straight. Okay.
Well, that's what I was trying to say, that there are 12 courts that have let the law stand. They've let the law proceed, whether on technical grounds or other grounds. I mean, you know, as a lawyer and as a litigator, as I was a litigator too, that those are wins. When you win the case on technical grounds, the law is allowed to stand.
But you're now using it to say that this judge is an outlier, but that's not true. You got 2 and 2. That doesn't make him an outlier.
No, the score is 12 to 2. Actually, the score is
substantively, Richard, as a lawyer, you tell me substantively. You're telling me the score is 12 to 2. Be honest.
Yeah, the administration won 12 cases and they lost one.
Not on the merits, Richard. On the merits,
and they lost. Okay. Well, on the merits, the score is 2 in favor of the administration and 1.5 against the administration, because the other case they lost, only the one little provision was thrown out as unconstitutional. It was not, the entire law was not invalidated. But I think if you look, I mean, we can get into this playing, who's won how many cases. I mean, obviously the Supreme Court will decide.
Listen, I don't want to get into any game playing. I want the viewers to have the facts. And Stephanie Cutter and you just now misstated the facts. So I want.
No, we agreed on.
You eventually came around to admitting the truth, but don't mislead. There's no reason to. 2 on one side, 2 on the other side.
Megyn,
and
please.
I know now you say that this judge.
I'm sure you don't think I'm misleading, because
you were in the beginning of the segment, Richard.
All right. Well, we can play it back. But you are correct, and that's what I said, that 12 cases were decided in the administration's favor. The cases were dismissed. There have been another 2 cases in which the administration won on the merits, and there is now this case, the first case ever where the entire law was thrown out as unconstitutional. That's an outlier. It's the first one ever. There have been many other cases on the other side. But it doesn't matter, how many you win and how many you lose. The Supreme Court is going to decide this issue. It's not going to be up to these individual federal judges.
This is going to go up to the Supreme Court.
So let's look at some of the judges' reasoning.
Why throw this judge under the bus by calling him a judicial activist, but the White House, in a plain case of judicial overreaching? When, Richard, let me just tell the viewers, because you say 1.5. He's won because the other side has won, because the first judge struck down the individual mandate as unconstitutional, which this judge did as well, but did not throw out the entire law. But this judge, the reason he said, because the individual mandate fails, the whole law must fail, is because of what the White House, what the administration argued to him, which is that you cannot sever one piece of the law from the other. You can't just say the individual mandate fails. And this is from the judge's order. He says, the defendants concede that the individual mandate, this is a quote, is absolutely necessary for the Act's insurance market reforms to work as intended. In fact, this is the Justice Department, refer to it as an essential part of the Act at least 14 times in their motion. They're the ones who said it survives in total or it fails in total.
Well, but I don't think they would. The administration certainly would not suggest that if you're going to strike this part out of the law, that the entire law should be unconstitutional. What they're suggesting is that it's an integral piece of the scheme, not that if you find this unconstitutional that you throw out the entire law. But listen, the Supreme Court is going to decide this issue. This judge used some reasoning that I think people think was out of the mainstream. And I think what you see is it's an effort. There is this new conservative judicial activism. There's this new, conservatives used to say that if there was a duly enacted law passed by Congress, the courts ought to leave it alone. It's the will of the people. But now
even if it's unconstitutional?
Well, but I'm just saying that this is the switch. I mean, it used to be that they used to say, let the Congress enact laws and let the courts interpret them, but let's not have them thrown out wholesale if they're duly enacted and they're the will of the people. This health care law is clearly the will of the people, as
it's the will of the people. But if it's unconstitutional, the will of the people doesn't get to stand. Listen, just so our viewers know, the two judges who have upheld the law on substantive grounds were appointed by Democrats. The two judges who have struck it down were appointed by Republicans, and the U.S. Supreme Court will take it up eventually. Richard, I got to run.
Remember when George Bush used to say, George Bush, President, our last president, George Bush always used to say, judicial activists.
Right. There's different definitions depending on who you ask. Okay, Richard, thank you.
Thanks, Megyn.
Well, it is the federal program meant to focus on deporting the most dangerous illegal